All right. Well, welcome to another Lunch and Learn session. I am James Greenwood. I'm an attorney licensed in Iowa and Illinois. I'm here with Benjamin Young today. He's also licensed in Iowa and Illinois now. Ben and I, our practice is in primarily estate planning, probate, and other related matters, although I do a little bit more litigation and a little bit more business work than Ben does. So today we're talking about testate versus intestate probate. Let's start with the basics, and before we get started, I think Ben, if you have some thoughts and maybe how to address this, I think the best thing we can do is say, what's the difference between testate versus intestate probate? What does that even mean? What does testate probate mean? Let's start there.
Well, I will start by letting you see James is driving. I'm currently at home, so if you do hear my 1-year-old crawling around behind me, my son likes to make a little bit of noise when he sees his dad on camera. But no, so the difference between testate versus intestate means whether or not you have a last will and testament. Did you actually write down what you want to happen with everything when you're gone and who's going to be in charge? If you don't write that down yourself, Springfield actually already has a plan for you, and that's what's called intestacy. And I've been doing seminars for over a decade now over this, and I have yet to ever hear somebody say they're really excited about the fact that Springfield has a written plan for them. But what it really means is there's just a default plan if you don't have a formal written down last will and testament to be able to subject that to the courts for their approval.
Okay. Excuse me, I'm sneezing here.
I'll cover a little bit more there too. I mean, one of the big things there is if you don't decide who is going to be in charge and who's getting what, a lot of times that plan that is the default doesn't line up with kind of the standard way that people are looking at things. One of the biggest differences I see is when people come in and do their wills. Most of the time, and James, you'd probably agree with this, probably 95% of the time, spouses say they want everything to go to each other and then go to the kids after they're both gone. But Illinois doesn't actually agree with that with their default plan is if one spouse passes, only half the assets go to their spouse while the other half goes to their kids. And their spouse and children, and I typically what it is they're going to be equally entitled to become the executor of the estate after the spouse is gone. So again, all of a sudden, when we talk to clients, most of the time it's the kids don't have a say so until both spouses are gone. But Illinois right away automatically wants to make it that the kids are involved when one spouse passes away.
And I think that is probably the single largest difference between almost all of the plans that I do for married couples versus folks who might otherwise not have a plan. So I definitely agree with that. That is a super common thing that we see. I think the other thing that we see, a lot of times is the planning for disability of a spouse. There really isn't a plan in the intestacy statute if there's a disabled spouse or a child that's disabled. I think that's one of the biggest gaps there. But again, that's a little out of what we're talking about, because that's not necessarily probate, but it is how things go. So let's kind of talk through when people hit probate and all of a sudden they find out, hey, we've got to go into probate. What triggers that conversation even, really, Ben? What are the big triggers for you when you're listening to somebody, their spouse or their loved one has recently died, and now they have to somehow get stuff? What are the triggers that make you say, maybe we need to discuss a probate in this case?
So I always start with just kind of what is the real purpose behind probate? And really, it's just to get things from point A to point B. Whether there's a will saying where it goes and where point A and point B is, or if there's no will, where Illinois says point A and point B are. But what happens is if you pass away and there are assets in just your name, somebody needs the legal authority to be able to transfer those from the deceased person to the person they're supposed to go to. So when I'm talking to my clients in their first meeting, Illinois has two rules on whether or not a probate has to be opened. One is, do you have assets over $100,000 in your name that don't have beneficiaries or a joint owner, or do you own any real estate in the state of Illinois? And if you either have either one of those, the only way someone is going to have the authority to transfer those assets is by opening up a formal probate with the court.
And now I will say, we use some strategies for probate avoidance where maybe the real estate is less valuable. There are a couple of bypass strategies that we've used in the past. Occasionally, we've had financial institutions agree to distribute assets that are in excess of those limits on some conditions, and sometimes we've been successful with that. But it typically, yeah, I would say those are the breaks.
And then I would always say too, we're attorneys. We're always looking for loopholes in these things, and that is definitely a caveat. But even some of those options tend to be more expensive than going through probate at the end of the day as well. So it's just it depends on how quickly the property needs to be transferred and whether or not you're willing to pay for the convenience of avoiding going through a probate as well.
Absolutely. And sometimes, if there's, certain property values, typically anything over, at least for now, we my trigger is about $150,000 is where I say, yeah, we're probably going to have to talk about, either direction, because in that $150,000 to $200,000 range for now, at least, we have to have all of our conversations. So below that $100,000 point, a lot of times we'll have a conversation about alternative strategies and things like that because of the cost of probate and other asset and other things. But yeah, I think that's a good set of points. So the other things, I guess. So let's say that we're going to probate. And we're walking in, and we walk into the judge and we say, well, hypothetically, we walk into the judge and say, well, judge, we'd like to open a probate, right? And what's that judge gonna hypothetically, again, all of this is very imaginative and hypothetical. What's that judge gonna tell us? What do we need to open up that probate?
Yep. So again, first of all, the three requirements for opening the probate is one, a petition for probate, which goes through and it states who's supposed to receive what, who's in charge, and where the person passed away. And that's the big thing with a petition. Next, you're going to look at an affidavit of heirship. And what that affidavit of heirship, it's a narrative that explains to the court who the family members are, who would receive things if there was no will. That's where they want to know, was the person married multiple times? Did they have children multiple places? Did they leave their assets to somebody other than their family? That's another thing that they're kind of looking at there with that affidavit of heirship. And then the final thing is the oath and bond, which is a promise by whoever's going to be in charge that they're going to do everything they're supposed to do as the executor or administrator. So what that includes is things like getting the bills paid and taking care of any arguments and claims over the estate. And then also, if required, sureties under that oath and bond as well, protecting the court if the person turned and ran off with all of the assets of the estate.
And so, and it's not, I guess, yeah. And those sureties, typically, what are the requirements for a surety? I mean, can I just get little Timmy down the street who's just graduated from college and has $100,000 in coffee debt to his name and no job? Can I get him to be my surety?
So the surety process is one of the biggest headaches of going through probate because what happens is the person serving as a surety has to fill out a financial report that's actually submitted to the court where the judge determines whether or not they're a viable person to serve as that surety. So what that typically means is they want to know that they have a net worth that would be enough to cover the replacement of the property if the person in essence disappeared with that property. So again, two requirements. One, it can't be typically somebody just directly related to you. The court does not like that. The other is finding people out of state. The court does not like that because they don't have jurisdiction over it. And then, just as you mentioned, the person that's more than willing to sign off on it, but then you find out their net worth is potentially negative, judges are definitely not going to be happy with that person trying to serve as a surety.
Absolutely. And then, you know, and then I think this is one of the biggest pieces, one of the biggest differences between with that will and without that will. I mean, if I have a will, do I still have to have sureties?
As long as the will waives the requirement for the sureties, you do not have to have the sureties. Now, I will tell you that the majority of wills do. So, something as simple as just having a will put in place saves whoever you named in charge from having to go through the very awkward process of having somebody submit their financial details to the court to be approved as a surety. So, that is easily the one of the more difficult steps to avoid just by having a simple will put in place.
Awesome. And we talk a lot about um, having a will, but um, have you ever run into a situation where maybe that will was one of these wills that we see every so often? Maybe it's handwritten, or maybe it's based on some form builder somewhere. Not to name any names, but there are a million and one of these online where somebody goes out, they do their will, and maybe one of the people signing that will um, is somebody who's not eligible to sign the will for some reason or another, or maybe somebody is eligible, but maybe they're um, maybe they have something that's going to happen as a result of their signing that might be unintended. I mean, have you ever seen that type of thing happen before? Um,
Yep, I have definitely seen that. So, I mean, the big thing there is a fill in the form sort of will. If it's not Illinois specific, what can often happen is it's not a valid will in the state of Illinois. And if you do not have a valid will, it's exactly like not having a will at all. So you might feel really nice that you paid some money to have this will done, but if it's not done correctly, it's just as much as not having a will. And that also kind of lends to another situation we run into a lot is not having the original will after somebody passes away. Is if we can't find that will, the assumption in Illinois is that the original was destroyed in an attempt to revoke that will. And again, that's another place where maybe you thought you had a plan put in, and then when you pass away, all of a sudden you find out that's not the case, and your family has to go through it as if there was no will. So it's really important for one to make sure that you have a validly executed will in the state that you live, and two is making sure you keep that original to be able to file after somebody passes.
um, let's say that I'm going through my parents' house, um, and after they pass, I didn't think they had a will, but I find a will from 1978. Do I have to do anything with that will in Illinois?
Yes, you do. You are legally required to get that will filed because if you secret it, it's actually a felony in the state of Illinois. So you definitely want to make sure that that's something you're not hiding from the court and you do get that submitted.
And as far um, as kind of that process afterwards, we get that probate opened up. Things are going along smoothly. Um, Say my parents have a house. Is there any difference between that would drive a cost difference to the estate um, between somebody who had a will and somebody who didn't? that we see frequently, at least. And it's not every will, I understand that, but typically, what would one example of that look like
So one
on
of the
failure?
biggest areas is when things aren't written down, that's where it tends to either cause friction within the family or just arguments over who gets to be in charge. If somebody's hiding something, there's a lot of kind of the opinions of maybe what mom and dad's last wishes were. So when things aren't written down, it tends to take longer to get things done. So I have one very good example that I'm dealing with right now where the husband passed, leaving his wife and stepchildren and his children, but it was his third marriage. And now all of a sudden it's an argument over who gets to be in charge and who is actually supposed to get what things because there was no will left behind.
And and I would point out, if there's a house sale, one of the common powers that we see in wills, at least all of the wills that we draft, is the power to sell real estate. I would say in an intestate estate, which is one, again, without a will, we actually have to go to the court to get permission to sell that real estate if it's not directed, if there's no directive that authorizes it and that authorizes the power to sell. Whereas if we have a will, that will can incorporate those powers and the authorization to sell that real estate. And we really don't have to go back to the court for that special permission for that. And so that can be incredibly useful in scenarios where there might be a lot of friction, because every time you go to court, there's an opportunity for somebody to show up and throw a fit. And they have a right to. I mean, so they certainly have a right to be heard. But the reality is that I think part of the probate process is really to get the creditors paid, get the assets distributed, and we have to do that in a fair and reasonable way. And a lot of times, the only way to do that is to sell real estate or to liquidate assets. So, so I would say, that's a big difference that I see, and it does drive cost, because every time we walk into court, or we have to prepare all of the documents for the court, we have to file those. Most of the time, we're able to successfully do that without the need for a hearing, but sometimes we have to have a hearing, and that's just the way that it is. So,
And just with the nature of the court process, anytime we can remove the court from the process, it's going to keep things simpler. It's going to make things more efficient. And at the end of the day, it's going to save the client money by being able to keep them out of as much as we possibly can.
Absolutely. And frankly, I feel like, the judges always appreciate it when they're not having to get involved at every single turn in these probates. And so, because the court is a limited resource. I think that's one of the other things that people don't realize is their taxes go to pay for that court. And the more we have to use the court, the more judges and the more court staff and the more everything else. So it's good for everybody if there's a plan in place that reduces the need for that court to the extent possible. There are times when you just have to do it. But I think that's one of the other philosophical pieces that I'd like to impart to my clients is, hey, look, these are limited resources. The judges have so much time in the day. Everybody has 24 hours in a day. The judges have 8 hours or 9 hours where they're available on a bench to make those decisions, those hard calls. And really, the only calls that the judges should hopefully have to be making are the really difficult calls. That's what they're there for. So hopefully, we're able to resolve all the easy stuff up ahead of time. And I think that's one of the big things that a will provides is that a testate estate provides for the court is it provides that all of the little decisions are more or less already made. So, all right. So turning to kind of the closing, all estates we go ahead, we publish, we have a publication period in Illinois of 6 months from the date of last publication. There's when we get past that 6-month period and we're out of the time for somebody to maybe challenge a will, which is a whole presentation all on its own. uh, you know, are there any differences in how we approach um, closing out or distributing the estate?
Well, again, I think part of that is how long is it going to take to sell the house if we have to get court approval on a lot of those things? And one of the other bigger items there too is who all receives notice of everything that's going on in the estate. So when you're intestate, typically there's a lot more people that all of a sudden have an interest and the right to be notified to everything going on, as opposed to if in your will you're able to limit that, it just makes things significantly simpler and quicker and easy to close out. But again, all that paperwork still has to be submitted to the court as to, again, who's getting what and if they actually received it.
Absolutely. So when we have the yeah, and I definitely see that. So when we're kind of closing things out, one thing I will say is once the challenge period has expired, the period where you can challenge that will has expired. Typically, our notices, we send them out. People get notice. Hey, these are the legatees. This is what they're getting. Here's where all the creditors were. Here's where all the payments were. That stuff does go out. Illinois, in theory, you can waive the final accounting if it's a uncontested matter, and if all of the creditors have submitted their releases. In practice, a lot of times we end up having to do that accounting anyway. And so I would say theoretically with a will, from what I've seen, my experience has been that it's usually easier with a will to get that accounting waived because everybody has to consent to it. All the parties have to. And if that will's in place, I would say that it is easier to get people to consent to it because they can look at the will and they can say, hey, here's the directive. Here's what, here's what the executors provided. I'm willing to waive the filing of the accounting and the hearing on that because I have reasonable certainty that, based on these documents, that the executor's done what they're supposed to do. So I think that's one of the big differences as far as options that are available. It does open up some options that are available for privacy purposes, as you're closing out the estate. Now, I will say courts, always have a right to decline to waive that accounting. I think I've seen that a few times where we've submitted requests to waive and the court directed us to go ahead and file the accounting for could be any number of reasons. And so it does happen sometimes, and sometimes the courts are concerned about transparency and making sure that people are getting what they're supposed to get.
And like you said, one other thing just to add in there is that, okay, with the will, you see what mom and dad wanted versus trying to rely on Illinois law. And what that does is more people getting on Google and trying to figure out the law themselves, which just like you can imagine, they always say Dr. Google. Well, this is lawyer Google, and it can just cause all sorts of conflicts over what does the Illinois law mean and things like that versus trying to already know what mom and dad wanted.
And I think that's one of the big issues. And then the last thing, and I would say, we deal with a lot of non-traditional families, kind of across all of our offices. And I know that Dr. Steph Acello, who's not here today down in Georgia, really is quite focused on our non-traditional families, including our LGBTQ plus set of folks. And when we do those wills, a lot of times there aren't traditional family structures in place that a lot of the pre-made distribution plans tend to rely on. So one of the things that's become very important in our planning, I think, is having a clear picture and clear understanding of things like fertility treatment and fertility um, opportunities where people are having children across a number of different states potentially. And that's going to get, I think, more complicated as time goes on, especially with the current political environment. So it's something that we have to keep in mind as we're moving forward. And here in Illinois, we have some of the most friendly laws for that type of planning. But we also want to make sure that we have those opportunities taken advantage of. And I think the other thing that we really try to do when we're doing the planning ahead of time is identifying, well, what happens if maybe these folks are a little older and they're not planning on having kids, and maybe it's a non-traditional family, or maybe it's somebody on their third or fourth marriage. I mean, that happens all the time, right? So it really allows us to hammer down and hammer into kind of what people want and put that in writing. And I've had a number of people over the years just give everything to charity. I mean, that I see that very frequently in our non-traditional family scenarios, where they're like, look, I don't want to deal with this. I want everything to go to, my local church, or I want everything to go to this youth outreach program that, helps young people in this particular community or that community. We've done a few of those. And it's been very interesting having those conversations with people about what they want and how do we accomplish that. And a will is a good baseline tool to use in those scenarios. Another place I would say wills can be very useful, and places where we're going to probate probably anyway, would be people with high risk jobs as far as opportunities to get sued. Doctors are a great example of that. We may, for a physician or for a nurse practitioner who is out on their own, lawyers. We don't see a lot of dentists getting sued, but what could happen, right? Any other professions where you can think of that we would just probably probate anyway, Ben?
Those are usually the typical ones that I think of that you just listed there.
Yeah, maybe chiropractors. I've seen a few chiropractors get sued after they die, but it's pretty rare. But one of the big things about probate is it does cut off those creditors' claims if done properly. So I think it can cut off some of the creditors' claims if done properly, and potentially cut off some lawsuits. So it's definitely worth a look as a strategy. But we'll definitely, if we run into that, we can talk about it. So it's certainly something to kind of consider. Maybe we should do a whole episode on that. But anyway, all right. So
let me jump back to one more thing you talked about though too. Just a different trend we see nowadays too is a lot more couples not getting married. That's another big aspect of having a will done versus intestacy, because again, we're not looking at some sort of common law marriage or anything like that. But if you have a significant other you've been with for a significant amount of time, Illinois does not automatically provide for them. So making sure that you have that written down, or just like you said, later in life marriages, again, Illinois does not provide for stepchildren. They provide for biological children or adopted children and spouses. So again, if you're looking at stepchildren, a long-term partner that you're not married to, the only way they're going to be able to receive something is by having some sort of written plan down and not relying on the intestacy statute.
The last thing I will say, before we go, is if you know that you're going to be dropping somebody into a hot mess, and you've got substantial assets, and you know that it's probably going to go to litigation, consider getting a professional as your administrator or executor, rather. And the reason really just boils down to, people, your kids, your spouse, if they have to litigate, it is all consuming, and they get sued maybe once or twice in their lives.
James, I think we lost you there.
Oh,
nope, keep going. That was me. That was Unshi.
Okay. Yeah. And really, your spouse or kids, maybe they might get sued once or twice in their lives. For a professional trustee, and I'm not a professional trustee, I don't think Ben is either. But for our professional trustee friends out there, it's Tuesday. You know, they get sued, and it's just another day, a day at the office. I mean, it's just how it works, right? They get sued all the time for all sorts of reasons, and they have professionals who work with them, you know, for litigators who specialize, focus in those areas, and they're really good at what they do. So if you know that it's going to be a hot mess, that is just a suggestion for everybody: get a professional involved. But that's what I have for today. You know, thank you all for joining us. The responsible attorneys in this presentation are James Greenwood and Benjamin Young. In the event that you want to call us, you can reach out to us at our phone number, which is, Ben, what's that 855 number again?
It's 855-528-6022. That's 855-528-6022.
All right. Thanks so much for joining us. James Greenwood, Benjamin Young, signing off.